My Lords, I'm grateful for the time. I estimate, as much as barristers ever do estimate, that I'll be in the region of 15 to 20 minutes, no more. Can I just say, I think I indicated, in fact, Mr Evans was going to hospital. I think, in fact, the strong suggestion was made that he'd go to us as opposed to actually on the way. Certainly, he was struggling to make himself coherent.
Well, we hope that everything is fine for him. Thank you.
Can I just mention one or 2 points? Your Lordships were concerned about were there any particular cases in where the particulars of the offence were of a limited nature and may convey a singular act and where, in fact, it may have a greater impact. And I'm assisted by Mr Bryant in this, and I've mentioned this to my learned friend, and it may be one of those items that will need further amplification in a skeleton argument. But the case is Soroya, which is it's a 2022 case, in fact decided in May before the Court of Appeal. And there involved a case involving a benefit fraudster who was charged effectively with a single matter of misrepresentation as to what was contained on a document with a view to obtaining benefit. And the question, in effect, for the Court of Appeal was whether the moment the document was produced, the offence effectively took place, or whether it took place over a period of time for the purposes of confiscation. And their Lordships in that case came back and indicated that it was with the contemplation, statutory contemplation, and this is at paragraph 39, that it applied to a claim being made with a view to obtaining benefit. So in other words, although it was quite a narrowly defined offence, it was very much made with the contemplation of a wider gain being made, notwithstanding the fact that it wasn't actually pleaded in the indictment in that way. I apologise, I don't have a copy of the authority immediately to hand, and I'm grateful, Mr Bryan, but as I say, we can expand on that further.
Have you got the page number of the law report?
Yes, forgive me. So the citation is 2020 EWCA Crim 602. And
2022?
Forgive me, 2022, yes.
Thank you.
And the paragraph where they talk about contemplation is at paragraph 39 of that judgment.
Thank you.
Can I also just make reference to compensation and indeed reputational damage? As I indicated earlier, there was a statement from the Chief Executive who was appointed to St Mary's Hospice afterwards that dealt with the issue of reputational damage, and in fact it was quantified in the way that how much their fundraising had decreased following the events, I believe, in 2016. But that application, to be fair to my learned friends, was not pursued in those terms. But as I've already indicated, the recorder was concerned about attempting to compensate the St Mary's Hospice. Can I just deal with it? And my learned friend very helpfully reminded that I hadn't dealt with it in reviewing some of the points that he made in his skeleton argument. It's at paragraph 45 of his skeleton. And I think we'll get the reference in the moment as to where it appeared in your bundle. But it's at paragraph 45.
84.
84, I'm very grateful to my learned friend. Where it talks about the application of the Bank Mellat approach. And broadly, dicta in relation to proportionality, in relation to civil cases, clearly have application in considering the meaning of proportionality in the context of criminal confiscation cases, subject to, obviously, the caveats that the civil cases, not that this necessarily should make any difference, but are not dealing with it in the face of the statutory confiscation regime, which I think all parties concede is a draconian one, and were not being considered in that context. I think it's also right, though, and properly conceded by my learned friend in terms of the focus, though, of civil cases may in fact be in relation to loss as opposed to what is faced by those dealing with the statutory regime. In other words, confiscation is concerned with gain to the offender and not loss to the victim. But in any event, we don't dissent from the general propositions that are set out there in relation to proportionality and the meaning of proportionality subject to those caveats.
Well, I mean, it's very hard to see how the first three of the four presented Bank-Mellett tests could arise in this context, because the objective has been dictated by Parliament and involves the interference. The rational connection again is obvious, and the whole point is that the measure that Parliament has chosen to achieve the disgorgement really doesn't give rise to the third question. So you're forced straight into the fourth question. Exactly so.
And that is perhaps really what is at the heart of this case. And it's set out at paragraph 73 of my learned friend's skeleton. It's under the heading, in fact, of partial restoration.
And what's the difference, just before you move on from paragraph number 4, what's the difference between that and the requirement to achieve a fair balance between the demands of the general interest of the community and the requirements of protection of the individual fundamental rights, and an individual not bearing an excessive burden? The fourth Bank-Mellett test, do we have to apply it at all if we've got another test which is applicable, which comes from the Strasbourg court?
Well, we would certainly invite you to apply the dicta of the Strasbourg court, and it may be that what is set out in paragraph 4, your lordships may find is not required to be addressed. Certainly, in general terms, and I'd particularly looked at paragraph 2, whether the measure is rationally connected to the objective. And certainly in terms of what is set out at paragraph 4, as I say, needs to be, as I've hopefully made clear, read in to the caveat of what's contained in relation to confiscation cases and the criminal law. So I suppose the general point, and it may be for my learned friend to explore the Bank-Mellett more fully, but our general point is, in relation to that, is while expositions on the meaning of proportionality are helpful from civil cases, they do have to be read in the context of some fairly large caveats.
And it isn't the main point that we've got a statutory test of proportionality, which one would not expect to be interpreted any differently than paragraph 4 of the Bank-Mellett approach?
Yes. And if I may, just returning then to paragraph 73, is that it's set out there, so the respondent in this case has made full restoration of the salary for which he's received. I think it's just worth pausing there and just considering a simplistic example, if in terms of what actually occurs in relation to this offending behaviour, that a deception is made, the work is then done, and then a reward is then paid. To the man on the street, the man on the Clapham omnibus, it may seem odd to suggest that where the work precedes the reward, that work should be considered as restoration in the normal meaning of that word.
What about analogous to restoration?
Well, that's akin to it, but whether one looks at it as restoration or even analogous to restoration, restoration means you are restoring what you didn't previously have. And here, Mr. Andrews, whichever way one looks at it, while on one view it may be argued that St Mary's Hospice have not lost in the sense that the work has been done, he has gained and retained the object of his criminal enterprise, which is the focus of the statutory regime. And this really is, we say, the heart of it. The alleged full restoration, we say no. And as I've indicated, we say that sale was wrong because it allowed them to discount the cost of their criminal enterprise. So corporates can deduct the cost of their operation. And if one returns to the example of the drug dealer who has rented a warehouse, he may be employing individuals in that warehouse, for example, maybe unusual, but he may be employing individuals to complete applications for company, to set up a company to support his illicit activities. He may be paying, on the face of it, salaries to those individuals who are working in the bank, who may be wholly unaware of what they are doing, that it's part of an illicit enterprise. And that individual, on the face of it, if sale, we say, is right, is able to deduct the cost of that, should be, based on sale, should be able to deduct the cost of that against his profit, because on the face of it, those people working in the warehouse are carrying out potentially legitimate activities. And we say simply that that is right. Of course, we say the intention behind sale was to put those behind sale back in the position they were prior to their criminal conduct. And the court in that case were able to achieve that by removing the profit element. But we say that ignores the general principle as set out in Wire that individuals should not be able to deduct the cost of their criminal operations. And while on the face of it, it is legitimate in terms of the work they were doing legitimate, it forms part of the overall criminal enterprise.
Of course, to an extent, you've already, in a sense, allowed certain expenses, in the sense that nobody's suggesting that you get your gross salary taken away.
No.
We're talking about net of
yes.
Tax and national insurance. But you say that that's because that's all, or do you say that's because that's all the criminal actually ever really, in any real sense, received?
Yes, it's not in any real sense received. And arguably, of course, that might be disproportionate if an order was made that didn't make allowance for that. We do say that the case of Asplin is an interesting case, but what was certainly the trial judge in that case, we say, was getting close to coming to our position that we put forward here.
Can you just give us the reference for Asplin or point out?
Forgive me. Yes, would you like to just bear with me? We do...
Or just remind us about the details of it.
It's EF 434.
434, EF 434. And forgive me, there is a part there, and forgive me, I had a reference to it, which I've now, I cannot locate, but certainly it's right to say the trial judge, we say, was close to adopting a similar position, where in that case, by holding their salaries were a necessary element of the fraud. Now, my learned friend is right to say, well, that case, I say he's right to say he is right when he says that case is different in that it involved an underlying much wider conspiracy to defraud. But it was the wording the trial judge used in that case, by holding their salaries were a necessary element of the fraud, is akin to what we are saying here. That the work done and the salary received is all part and parcel of the criminal offending behaviour.
That may have the effect that whether or not there is scope for the court to take account of proportionality may depend on the way the Crown frames the charge.
Yes. Yes. Yeah. Can I say, I was intending to deal with that paragraph 86 of my learned friend Skeleton. He deals with the examples of the surgeon, the pretend surgeon, or the surgeon pretending to be one. I think he phrases it in that way, or words to that effect. And it's set out at paragraph 86 of his Skeleton argument. And in fact, it was something that was dealt with in the course of legal argument in the court below. The issue of the qualified surgeon who embroiders his application. And I hope I've made it clear, and it may not need repetition, but as I've indicated previously, the surgeon who embroiders that application in a minor way may not be guilty of the offence or seek to argue that there was no continuing gain. It got the job him initially, but thereafter did not. The pretend surgeon is unlikely to be able to follow that line, because his deception would likely to be operative throughout the period of his employment, as would anyone who had failed to obtain the qualification that was regulated by statute. And as I think I've indicated previously, the filter is offences and the confiscation regime, and whether somebody is full foul of those offences or the confiscation regime, not proportionality. My Lords, I'm conscious if I go on further that I'm repeating the same point again and again, and I don't think my case or our case would benefit. I simply leave you by way of conclusion with this thought that, and it's currently effectively enunciated in Archbold, which many, of course, practitioners, criminal practitioners up and down the land use, is that in effect, CV fraudsters commit crime, commit maybe a potentially substantial misrepresentation, and subject currently to the line about whether they're barred by statute from doing the job, may suffer a criminal penalty, but will never have to pay the money back. And whereas the confiscation regime is not primarily concerned with deterrence, it is concerned with removing the gains from their criminal conduct. And we say, and the reason this appeal has been brought, is that those individuals are able to retain the proceeds.
You're citing from Archbold?
Forgive me?
You're citing from Archbold?
It's set out, forgive me, it's set out at Archbold.
What's the reference?
I believe we've included it, and if I haven't, that may be... would your Lordship just bear with me one moment? It's certainly an Archbold that's contained. It's a limited reference.
A comment on this case in the Court of Appeal.
It's a comment on this case in the Court of Appeal. Would your Lordship just bear with me? I'll have the reference shortly. But in essence, as we say, the simple position is that the objective of the statutory regime is not being addressed.
I don't think it's in our authorities, but you can give us the page reference later.
Yes, if I may.
Of course.
I should...
Brown, would it also be possible at the same time to send us a copy of the EWCA criminal case that you referred to?
Yes, of course.
and also a copy of the extract from March.
Yes, I'll simply send a copy of the extract. That might be easier. Can I assist your lordships any further at this?
There was just the burden of proof point that I think you were going to come back to, but it may be that that's something you'd like to send in instead.
If I'm able to send that in, I'd be grateful. Thank you.
Thank you very much. Mr. Ashley Norman, you have an extra 5 minutes after 3:30.
I'm obliged, my lord. My lord, the burden of proof is on...
After 4 o'clock, as you would say, sorry.
The burden of proof is on the prosecution. The prosecution must seek a proportionate order. And if the order is not proportionate, then the court should refuse to grant that order.
Is there any authority for that? Is there any authority for it? Because I was bewildered by the double negatives in section 6, subsection 5.
Yes. If there is, we are likely to come upon it in the course of the review of the authorities I'm about to embark upon.
Thank you very much.
But in my respectful submission, these being criminal proceedings and confiscation, the burden on benefit being on the prosecution, it is for the prosecution to prove that the confiscation order it seeks to have imposed is a proportionate one.
The court can depart from what is sought and make another order, is that right? Or?
It can, my lord, yes. It can make an order which it considers to be proportionate, which might be smaller or lesser than that which is sought by the prosecution.
Don't want to take up too much time, but there's an obligation on the court to make a confiscation order in the available amount, unless it is disproportionate.
That's correct, my lord, yes.
Okay.
My lord, if I may, I'd like to take the court back to the indictment, which we saw fleetingly this morning. It's at EF 223. My lord, the important first point to note is that insofar as my learned friend was talking about obtaining property by deception was not the indicted offence. The indicted offence was obtaining a pecuniary advantage by deception, which is important because of the phraseology used in section 76, 4, 5 and 6 of the Act, to which we'll come in a few moments. The offence of obtaining a pecuniary advantage by deception, and indeed the offence of obtaining property by deception, both of those offences were repealed in January of 2007 upon the implementation of the 2006 Fraud Act. And that is why the counts that were faced by Mr. Andrews and to which he pleaded guilty reflect different criminal offences. Count 1 being the obtaining of a pecuniary advantage by deception. And here I must differ from some observations made by my Lord Hodge in the course of argument with my learned friend, where my learned friend has submitted, and Lord Hodge taking his cue from my learned friend, my learned friend submitted that the performance of work was a necessary element of the offence. And I think my friend said that the offence would not have been committed if work had not been done. That, with respect to my learned friend, and appreciating the position that he is in, is incorrect. And I recognise that to a certain extent I'm arguing, as it were, against myself for a more stringent application of the law. But nonetheless, the offence in count 1 provides as follows: dishonestly obtained for himself a pecuniary advantage, namely that he was given the opportunity to earn remuneration or greater remuneration by falsely representing, and so on. The offence was therefore complete at the point of the application, and it was not a necessary part of the offence for him, the respondent, to actually carry out any work. To the extent that my friend has submitted otherwise, it's our respectful submission that he is in error. That approach, my lords, the approach that does not require him actually to have done any work to be guilty of the offence, was carried over to counts 2 and 3. Because of the passage of time, the offence-creating provisions had been repealed and new offences replaced them. Thus it is that Mr. Andrews faced and pleaded guilty to offences contrary to the Fraud Act, where dishonestly and intending thereby to make a gain for himself or another, he made false representations as set out in counts 2 and 3. Once again, no requirement that work should actually have been done.
So we're not concerned with count 1 at all in this case?
We are, my lord, in the sense that count 1 formed a part of the offences to which Mr. Andrews had pleaded guilty, and as a result of or in connection with, a confiscation order was imposed.
Right, sorry, I misunderstood what you said. Thank you.
So, I mean, the point you're making was I was too quick to assent to the view that count 1 required work to be done when I was making the point that counts 2 and 3 prima facie did not. Your point is that, yes, in fact, if you see the full statutory provision in relation to count 1, they, like counts 2 and 3, did not require the work as an integral part of the offence.
That's correct, my lord, yes.
Thank you.
Thank you very much. My lord, the next document, if I may take the court to, is the judgment in Weyer, because it conveniently sets out sections 76, 4, 5 and 6 of the Proceeds of Crime Act. They appear at EF 698. So at EF 698 is set out in full section 76, and if I can direct the court's attention of the Proceeds of Crime Act 2002, and if I can direct the court's attention to subsection 4, a person benefits from conduct if he obtains property as a result of or in connection with with the conduct. Sub 5, if a person obtains a pecuniary advantage as a result of or in connection with the conduct, he is to be taken to obtain as a result of or in that connection or in connection with the conduct a sum of money equal to the value of the pecuniary advantage. References to property or pecuniary advantage obtained in connection with conduct include references to property or a pecuniary advantage obtained both in that connection and some other. And, my lord, it is particularly with reference to subparagraphs 4 and 6 that we identify and indeed in our written case concede the causation point. Because the causation point, the causation test is a wide one, 76.4, as a result of or in connection with, and sub 6, obtained both in that connection and some other.
So, I mean, it's very hard to think of an employment case where there's a fraud leading to the engagement, which won't fall within that.
Precisely so, my lord, precisely so. And this, in our respectful submission, represents an example of what the majority in Weyer described in paragraph 8, further up page 698, as statutory overkill.
Yeah.
And an example of the statutory overkill is the apparently loose causal test in section 76.4, which is described as draconian. Now, the reason, my lords, that we have set out in our written case the history of these proceedings is that it describes the circumstances in which it was entirely open to and proper for the legislature to import that statutory overkill, since it was a statutory regime that was designed and intended to address the condign impact of drugs trafficking offences. That statutory overkill led to the apparently loose causal test. And I pause for a moment over the curious in our respectful submission use of the word apparently. The apparently loose causal test, which has the consequences which my Lord Kitchen has identified, which is that it is difficult to conceive of a employment case in which the causation test was not satisfied. And therefore, with respect to my learned friend, the considerable period which he spent addressing your lordships on causation is, in our respectful submission, nothing to the point insofar as it is to be considered a separate point to proportionality. It will be my submission in due course that causation is appropriate to be taken into account at the proportionality stage, or may be appropriate to be taken into account at the proportionality stage. But the statutory overkill that was imported into the Proceeds of Crime Act and its predecessor legislation is such that no complaint can be made of it before this court so far as the causation element is concerned. So, my lords.
So, sorry for interrupting, but this is property rather than pecuniary advantage, is it? Because property is money.
My lord, yes. The context in which the pecuniary advantage generally arises is that of tax evasion. And so, for example, cases such as Duran, which is amongst those which are cited in your lordship's bundle. Duran and his co-defendant, Gray, were cigarette smugglers. As the container of cigarettes, which they had caused to be smuggled, passed the duty point at Felixstowe Docks, the tax on those smuggled cigarettes was due to be paid at that point. At that point, by not paying it, Messrs. Duran and Gray received a pecuniary advantage, namely the evasion of the tax. That was their benefit, and that was to be equated through Section 74(6) and 5. That was to be equated as their benefit, notwithstanding that in due course Customs and Excise seized all of the cigarettes, and the benefit in cash terms, the folding benefit to Mr. Duran and Mr. Gray, was never realised. That is the context, my lord, in answer to your lordship's question, that the pecuniary advantage ordinarily or often arises in cases of that nature. The reason why it has no impact so far as the statutory obtaining for Mr. Andrews is concerned is the width of the words as a result of or in connection with. Because it is impossible for Mr. Andrews to argue, as my Lord Kitchen has identified, that his salary was not obtained in connection with the lies which he uttered at point of recruitment. My lords, I've taken the court section 76 with the apparently loose causal test at, as it were, the other end, and so creating the tension which proportionality ultimately resolves at the other end is A1P1.
You speak of an apparently loose causal test, but at the same time, that apparently loose causal test is the trigger of your concession. Why do you say apparently?
Well, I have the virtue of being able to quote majority in the Supreme Court on the last occasion.
It seems to, they may have used the term, but it seems to be more than apparent. Given the concession, it appears to be very real.
Well, my lord, the reason, the reason why the loose causal test may be more apparent than real is because the court is not deprived of the opportunity to look closely at the benefit that has in fact been obtained. In the case of Hayes, it was with some trepidation that I cited a case that is in the Crown Court, but nonetheless it was Mr. Justice Cook who dealt with the case of Hayes, to which I'm likely to come in due course, and which commences at EF page 541. And at paragraph 69, in a case of fraud of extraordinary complexity concerning LIBOR fixing and so forth, Mr. Justice Cook identified that it was necessary, paragraph 69 at page EF 560, that the court should seek to identify with as much exactitude as possible what are truly to be seen as the proceeds of the criminal activity in question as a matter of effective cause. This is necessarily a difficult process, but the court must, on a balance of probabilities, making all necessary inferences, seek to do this by reference to the evidence before it. Now, Mr. Hayes might have been subject. Mr. Hayes was a trader. He worked first at UBS and then Citibank, and he worked in the trading of Japanese currency in a manner I don't pretend to understand. Mr. Justice Cook was able to take the view as to his benefit on the previous page, EF 559. And Mr. Cook, who had Mr. Justice Cook, who had had the advantage of conducting the trial and had watched the trial unfold, was faced with an application for a confiscation order from the Serious Fraud Office, which sought to recover the entirety of Mr. Hayes' salary. And we can see that at the outset, paragraph 3 at page EF 542. The SFO claims that the benefit which the defendant obtained from his criminal conduct is over £3.8 million, which represented the total of his remuneration at UBS and Citibank between those dates. So the application, and the reason why I have included this in the bundle, notwithstanding its being a Crown Court case, is that it is one of the few cases which deals with employment in a confiscation setting. And it is, of course, a judge of considerable repute who deals with it. So he was faced with an application for a confiscation order in that sum, with a benefit figure in that sum. But he exercised he sought to identify with as much exactitude as possible what was actually obtained, and he makes the observations he does at paragraph 62. A list is there provided of what Mr. Hayes had done, which might justify the inclusion of the totality of his salary. Then at paragraph 63, the question then arises as to how much of the defendant's earnings in the form they took represent property obtained as a result of or in connection with his offending. In this context, there appears to me to be a significant difference between ordinary salary and bonuses. And erring on the side of generosity, I'm reading short, I'm prepared, erring on the side of generosity, to treat the salary paid to the defendant both at UBS and Citi as payment for legitimate activity, save for the 5% figure which the defendant accepted in his POCA statement could be attributed to the manipulation of LIBOR.
Well, this is very fact-dependent, isn't it?
It is, my lord, but the reason I have taken the court to it is my Lord Hodge asked me about the apparently loose test. In fact, that apparently loose test is capable of application with some high degree of exactitude, and as it was by Mr. Justice Cook in Hayes, and indeed as it was in the case of Weyer, when in the subsequent paragraphs the court looked at the legal mechanisms by which the mortgage transaction and the acquisition of flats went through, and the majority on that analysis came to the conclusion which it did as to the proper application of benefit, or proper identification of benefit.
I haven't read this case. I don't know what the facts are, but I just assume that he was an employee who got increased salary and bonuses by virtue of manipulating the market. And so what one had to find out is how much extra money did he get in connection with the manipulation of the market.
Precisely so, but the court, my lord, took a broad brush approach to that. The SFO argument was it was the totality of his salary which should be described as benefit, all of it having been obtained as a result of or in connection with the offending having taken place within UBS and Citibank. And therefore, the apparently loose causal test might have infected the totality of the salary of Mr. Hayes. But Mr. Justice Cook, by taking the care that he did in the identification of the benefit figure, was able to reach a benefit figure which ultimately was a proportionate benefit figure, which formed the starting point for the confiscation process, the next stage being the identification of assets. My lord, I apologise for that rather circuitous and unexpected diversion from the tension that I was seeking to illustrate between the loose causal test created and therefore the width of the causation available by section 76.4, and then at, as it were, the other end of the spectrum, Article 1 of the first protocol to the European Convention, which is conveniently set out at EF page 700. Every natural or legal person is entitled to the peaceful enjoyment of his possessions, and no one shall be deprived of his possessions except in the public interest and subject to conditions provided for by law and by the general principles of international law. The preceding paragraph provisions shall not, however, in any way impair the right of the state to enforce such laws as it deems necessary to control the use of property in accordance with the general interest or to secure the payment of taxes or other contributions or penalties. And therein, in our respectful submission, lies the one end of the tension, the width of the causation test being the other end of the tension, which tension is resolved by the proper application of the proportionality test in a manner which is described in the subsequent paragraphs. My lords, have asked us to consider whether
is that the same test as paragraph 4 of Bang Mellet?
Yeah, my lord, yes.
It is.
Yeah. Or it is reliant upon the same authorities, the same history within the European Court as was relied upon by the Supreme Court in Bank Mellet. My lords asked whether there is a halfway house in this case, somewhere between 0 and the 90,000 odd that was imposed, £96,737.24. It's our respectful submission that there is no halfway house. One can respectfully understand why the court might seek such a position, but there is no sustainable position, no sustainable halfway house, for two reasons. The first arises out of the terms of the Proceeds of Crime Act itself and the purpose of the Proceeds of Crime Act. The Proceeds of Crime Act is intended, as is manifest everywhere, to deprive convicted defendants of the proceeds of their crime. and the elements that might be capable of compensation and addressing within a halfway house are not caught in our respectful submission by the Proceeds of Crime Act. So, for example, the value of the loss to the employers by virtue of their reputational damage, that is not a benefit that has been obtained by a defendant. The costs of mopping up afterwards, as it were, the costs of recruiting a replacement for Mr. Andrews, none of those is a cost which is apt for description as the proceeds of crime obtained by Mr. Andrews. And so those losses which are postulated are not apt for reflection in a confiscation order. The second point is that they are only postulated. They are not and were not in the courts below evidenced at all, and are not evidenced before this court at all. And so, much like the potential benefit in sale, which was the benefit arising out of an enhanced market position obtained by virtue of the bribery, that benefit was not evidenced, and the court had no means of ascribing a value to that benefit. In the same way, or perhaps more accurately, additionally, any losses occurring to the hospice are not evidenced in this case. So there is no halfway house through the POCA regime. We have given consideration in the light of my Lord Stephen's observations whether there may be a halfway house through the compensation regime. And it is our respectful submission that once again it falls at the evidential hurdle. There was no evidence below and none before your lordships, pursuant to which such a compensation order might be imposed. But in any event, a compensation order which arises now, my lords, pursuant to section 133 of the Sentencing Act of 2020. It had previously been section 130 of the Powers of the Criminal Court Sentencing Act of 2000. But under the new code replicates the previously existing power to impose a compensation order. But that compensation order empowers a court to make an order requiring a defendant to pay compensation for any loss or damage resulting from an offence. And the authorities, therefore, as a matter of statutory construction, the sorts of damages, the sort of losses that occurred subsequently could potentially be the subject of a compensation order. But the authorities in that regard and for governing that regime make it plain that the compensation order regime is a blunt instrument intended not to be deployed in cases of any complexity where there may be difficult issues of causation and contribution and other contributing factors that may give rise to any losses which might have arisen. There is, as I've indicated, no evidence in any of those regards, and therefore the compensation order route as a means of creating a halfway house is not available to the court.
Can I just ask you about going back to the point about why there can't be a halfway house in line with the purpose of POCA? Leaving aside issues of loss, why is it not open to a court to take a view that it would be proportionate to make a confiscation order of part of what has been obtained as a result of the benefit? What's against the POCA regime? What's within the POCA regime that would prevent that?
No, that is a course that is open to the court, my lord. And that is precisely the course that was adopted in the case of Hayes by Mr. Justice Cook. He, cognizant of the entirety of the facts, identified that element of Mr. Hayes's employment which was infected by criminality, and having identified it, ascribed, broad brush, but nonetheless ascribed a value to it, and adopted that as the benefit figure. And that benefit figure was not the subject of an appeal, and formed the basis of a subsequent confiscation order in the amount up to the defendant's realisable assets.
I understand that, but I'm actually putting a slightly different point to you. We know here what the benefit figure is, I think. That's not in dispute. So it's the full earnings, net earnings. Why is it not open within the POCA regime when we are deciding proportionality to decide that only a proportion of that, whatever the figure is, 900,000 or whatever it is a proportionate amount to award?
My lords, it might be possible to do that. Were that approach to be adopted, that would come, as it were, at the later stage, at the final stage. Section 6.5 of the Act and the amendment to Section 6.5 of the Act implies that the proportionality test should be exercised at the end of the confiscation exercise.
I accept that, but I don't think it alters the point that I understood you to be saying there was some objection within the POCA regime to awarding a part award on the basis of proportionality. I understood you to be saying, well, you can't really do that.
My lord, our submission is that that cannot be done in the circumstances of this case. And the reason that we so submit is that in the circumstances of this case, Mr. Andrews has provided something which is analogous to full restoration. He applied it, he provided it on a month-by-month basis in advance. And the prosecution can identify no principled basis upon which it can be said that he did not provide something analogous to full restoration in this case. This case does not contain features like those which arose in Hayes, where it can be said that elements of his salary or elements of his bonus were directly attributable to the libel fixing upon which he was engaged, and therefore those elements of his salary and his bonus are properly to be described as benefit. Mr. Andrews has no such feature in his case.
Well, he does on one interpretation, and that is through fraud, continuing fraud, he obtained a salary for a long period of time, financial benefit. And certainly from the perspective of the employer, they didn't get what they bargained for. They got a confidence trickster. So the concept that he provided full value or something analogous to full value is somewhat difficult to follow.
Well, my lord, the illegal immigrant cannot provide full value because he is not entitled to work in this country. The surgeon, the pretend surgeon, cannot provide full value because he lacks the qualifications which are required to enable him or her to do the task which he has pretended to be able to do. The pretend surgeon, commits a criminal offence every time he takes his knife to a patient.
I entirely agree. So we're dealing with a case at one end of a spectrum, and there may be another end of the spectrum, and that is the illegal surgeon who imperils life, who on every occasion that he operates, he commits another crime. And the illegal immigrant might be somewhere in the middle, insofar as if a factor relevant to be taken into account in the proportionality exercise is the nature of the actual employment and the degree to which it is illegal, then you can have different degrees of proportionality assessment, so that you have a less draconian confiscation order in relation to a person in your client's position, and a more severe one, in fact actually more than likely a total one, in relation to a surgeon, a pretend surgeon.
Yes.
And a less draconian one in relation to a surgeon who obtained his employment because he misrepresented that he had leadership capacities or whatever it might be. So,
yes.
What's wrong with that?
Well, my Lord, in our respectful submission, what is wrong with that on the authorities is that I agree, and indeed have submitted in our written representations, that there is a spectrum at play, but there is also a line within that spectrum. And the line within that spectrum is the lawful-unlawful line. And those who have conducted themselves through their labours every day committing a further offence, obtaining a pecuniary advantage by the deception that they are a surgeon, by the deception that they are legally entitled to work in this country, and thereby, by those acts, committing a criminal offence. On every day, that the salary that is received not only in connection with, but as a result of, a criminal offence committed that day. In our respectful submission, on the other side of the line, a line well established by, for example, Lord Justice Fulford in the case of Scott King. On the other side of those lines are those whose conduct does not amount to a criminal offence on each and every occasion. There may be associated illegality, but the conduct which is in fact being done is not a criminal offence. And day by day, in our respectful submission, month by month, Mr. Andrews was working, and then at the end of that month, receiving his salary for the work that he had done that month. And the work that he had done and the salary which was all legal work. No element could have been identified and separated out in the way that it was in Andrews, separated out as a component of his salary, which reflects the criminality that underpins his actions. No, through the work done on any particular month, that work was honest work, properly rewarded.
Well, then your proportionality test is reduced to whether it's criminal or whether it wasn't criminal. And just because you exclude from proportionality those whose ongoing employment is criminal doesn't really address why you can't have proportionality in relation to others.
Well, my Lord, I accept that. I can't argue for a spectrum, and then not recognise that there will be individual cases that may fall in particular places on that spectrum. And indeed, it may be that there are individual cases which might be considered differently now to how they were considered when first they troubled the courts. I think, for example, of the illegal immigrant case of Paulet. I think, for example, the shelf stacker, which I know troubled the court below, and indeed Nelson, Mr. Nelson, who had a stolen JCB in his yard, which JCB was found by the police 4 days after its theft, and which was nonetheless found to be, and upheld in the Court of Appeal to have been, obtained as a result of or in connection with the offending, therefore benefit figure, therefore confiscation order imposed. So,
sorry, in the Nelson case, just to stop you before you race on, he used the JCB digger and made a benefit from it, as I understand it.
No, I think my Lord may be thinking of Harvey.
Ah.
In Nelson, Nelson provided the thieves with vehicle documentation, to which they then amended the vehicle identification plates of the stolen JCB. And the stolen JCB was found on his property 4 days after the theft. He had obtained it, but not retained it. It was therefore a benefit which he had obtained as a result of or in connection with his handling of the stolen goods. Therefore, his benefit figure was the value of the JCB, just short of £20,000. He had £20,000, therefore confiscation order imposed. That was pre-Weyer, although not long pre-Weyer, and A1P1 was not argued in the Court of Appeal at Nelson. So the reason I have got to this point is in answer to my Lord Stephen's observations to me. There is a spectrum, and precisely where on the spectrum a case may fall may vary in time as well as on the facts.
It sounds to me that your submission isn't really a spectrum. It seems to me it's all or nothing. You've got a very sharp line. Well,
there are indicators along the way identifying where the confiscation order is the appropriate one, and the legal threshold has the virtue of clarity as an indicator to where on the proportionality spectrum a particular case may fall.
But like Lord Stevens, I would put it to you that even if one puts to one side the unlawful, where the actual performance of the services is unlawful, it's not clear to me why one, in all other cases, can't take a proportionate view about how much one's going to strip.
Well, my Lord, this, in our respectful submission, takes the court back to a consideration of the effect of restoration. And if restoration, or something analogous to restoration, has meant that the totality of the benefit has in fact been paid back to the loser, with heavy inverted commas over the word loser, then a proportionate confiscation order cannot be made, because a proportionate confiscation order cannot be made if it amounts to double payment.
But in an employment case, the employee who secured the position as a result of his fraud may retain a benefit, even though in one sense the person for whom he's worked may have received compensation. May he not? I mean, if as a result of one's fraudulent behaviour, one secures a position which one wouldn't otherwise get,
yes, yeah.
And as a result you do the work, your employer is pleased with it, but you end up with a good deal of money in the bank at the end of your term of employment, which you wouldn't otherwise have had, why is that not a benefit derived from your employment and your fraudulent behaviour, which you should, under the principles you've described to us, be required to disgorge?
My Lord, that employee has obtained the money as a result of or in connection with the offending. That is a product of the loose causal test. Therefore, that benefit figure is conceded. However, it is disproportionate to cause him to face a confiscation order in that sum, because the totality of his salary, he has made something analogous to restoration, because he has done the work in respect of which he has been paid.
You're arguing from the facts of this particular case, in which you're asserting that he gave full value. Okay? Now, assume that he didn't give full value. You still have the same benefit, because he obtained his salary in connection with his employment. In such circumstances where he acknowledged didn't give full value, shouldn't there be a proportionate order made?
My Lords, It's still difficult to see how such an order might be imposed or calculated.
Proportionality assessment. You just say that there we are. Rather than taking any detailed evidence about the matter, you can say, well, the value of these services that he provided over a period of time are diminished and within a bracket, say 10% to 20%.
Well, my lord, for example, if an employee were contracted to work 5 days a week, pursuant to a dishonest application, and he only turned up 4 days a week, but on those 4 days he gave full value on those 4 days, then a proportionate confiscation order might be made in the sum of 20% of his total salary, because he had failed, he had obtained as a result of or in connection with his lying application 20% of his salary when he hadn't actually done the work. So to that extent, I accept that because it is a fact-sensitive regime in which we are operating, the facts may be such that a proportionate confiscation order may be made in circumstances such as my Lord Stevens suggests.
Yes, but that's a quantitative measure. He hasn't done the work. But the employer here was wanting someone who had these qualifications and someone who was of integrity. He may have turned up every day, he may have done his hours, and he may have had very good appraisals, but he wasn't what the employer was paying for. I mean, the employer wanted someone of a different standing. He did not want a fraudster in charge of his organisation. So I struggle to see how one can say what Mr. Andrews gave was analogous to full restoration.
Well, my lord, in our respectful submission, dissent to the evidence in the case demonstrates, and it's referenced in the basis of plea and elsewhere, the progress that was made by the charity under the stewardship of the respondent.
Oh yes, he was a good manager.
Yes.
And somebody who was honest might have taken it further. But all that speculation. But certainly, I have difficulty in the concept that he provided full value, and therefore I'm very interested in what are the factors that should bear on the proportionality assessment: the length of time, the nature of the job, whether it's illegal, etc. It's obviously not a wide-ranging. It's not a discretion. It must be something else. And,
yes.
Yes. Particularly interested in that.
Yes, yes.
I put it to you just slightly differently while you're thinking about that. Supposing had the truth, in another case, had the truth been told, he would have been required to do the job, but for less money. In other words, the employer simply wouldn't have paid the same sum of money each month to somebody of a lesser qualification, even though in practice that person ended up doing a crackingly good job.
Well, and that would therefore provide a measure of what he had obtained over and above the salary to which he would have been entitled had he been truthful as to his qualifications.
And in those circumstances, would you accept that would be a matter to be taken into account in the proportionality assessment?
My lord, is it in our respectful submission difficult to conceive on the facts? Because
it's not uncommon to find people are paid a little bit more if they are better qualified. And they may end up doing what would otherwise have been the same job. But as I understand it, if the job is done well on your submission, the employers had full restoration, and so that's the end of the matter.
That is my submission, my lord. That is my submission, because were it otherwise, the Crown Court would have to embark upon the exercise which the recorder declined to embark upon, which is assessing the value of the work that was done by the respondent pursuant to his contract of employment.
With respect, is that necessarily right? Because the focus, as I understand it, of the exercise is on the benefit which the wrongdoer has obtained, rather than entirely upon whether or not the subject of the wrongdoing has been restored to the position that he would have been in but for the wrongdoing.
My Lord, the benefit test is indeed directed at the benefit which has been obtained by the wrongdoer. And I have made the concessions that I have in respect of the benefit in this case, because there is not a route by which a proportion can be identified of the service that Mr. Andrews gave, which can be ring-fenced as received as a result of or in connection with the offending. And to that extent, therefore, Mr. Andrews is in a different position to that which obtained in the case of Mr. Hayes. If the court is to make a proportionality assessment ascribing a percentage of Mr. Andrews' income to the offence, then there must, in our respectful submission, be an evidential basis for doing so. And there simply was none.
About that, I'm sorry for cutting across you, but I mean, for instance, in relation to contributory negligence, you form an assessment, and it's a broad, generalised assessment. I mean, you could go into what would Mr. Andrews have earned in the open market, but if he'd actually been honest and declared his proper qualifications, and compare that to what he did earn in this job, very convoluted method, or alternatively to adopt Lord Kitchen's approach, get some sort of evidence about what a lesser qualified person would be paid in this particular job, or alternatively another approach, which is just to take a broad general assessment as to what the court considers to be proportionate, and it's going to be different with a shelf stacker, potentially different with a person in your client's position.
Well, my Lord, I've made my evidential point about that insofar as the facts in my client are concerned. I'd also make this observation that whereas in the case of sale, in a company context, the profit was the appropriate measure of the benefit which had been obtained by sale in a commercial contractual situation. There is, in an employment context, no profit element which attaches, no means of calculating that part of his conduct which is reflected in the salary and that which is, as it were, on top of that.
Well, again, with respect, is that necessarily something? The whole thing is the benefit, but the question comes as to whether or not it's proportionate to require the disgorgement of the whole benefit, to which one says, well, there's been, the employer has been recompensed. And one of the questions that you've been asked by my lords is whether or not the employer truly has received full recompense, because the employer was bargaining for something more than he in fact got, that is to say, an honest person. But equally, at the other end of the line, it may be that the employee has also got more than he would have done had he declared himself honestly. And so there may be both an increase in the benefit that the employee has secured, which should be reflected in the proportionality assessment, and also a deficiency in the recompense that the employer has secured. And that too may need to be reflected in the proportionality assessment. And would it be right in those circumstances to adopt a fairly rough and ready approach to what that may be?
My lords, the The confiscation regime is one that is familiar with a rough and ready approach. It has been deployed in various circumstances. So, for example, the case of Chu and Xiu concerned Chinese immigrants, illegal immigrants, who were working in a Chinese takeaway, known to those who ran the Chinese takeaway. What was the benefit figure of those who ran the Chinese takeaway? The illegal immigrants represented 20% of the workforce, or similar percentage. Therefore, 20% of the turnover was the appropriate figure to be allocated to the benefit figure. And therefore, we respectfully concur with my lordship that a rough and ready approach may be appropriate in some circumstances, even in an employment context. But it must nonetheless be one that is rooted in evidence. And the only evidence which is before this court is evidence as to the efficacy of the services which were received, which were offered and remunerated month by month through the employment of the respondent. Employers may often become disappointed by their former employees, or by what they discover about their employees before they become their former employees. But that disappointment does not sound in damages. That disappointment does not enable that employer, without some other call for damages, for special damages, does not enable that disappointed employer to bring an action against the former employee for a return of the salary. Now, I recognise, and it's our respectful submission, it would be a curious state of affairs if the loser, in now heavily inverted commas, had no claim against the former employee in respect of the salary that was paid by virtue of the cases which we have referred to, and yet the employee in a criminal context was said to have obtained the entirety of, or even a percentage of, that same monies. And it is especially applicable in our respectful submission in our case, where the employers are identifiable, the payments made are certain, and the defendant, the appellant, the respondent, has not received any other benefit over and above that which arose from the employment. And so there is precise synchronicity between that which was, inverted commas, lost by the employer and that which was obtained as a result of or in connection with the offending.
Well, I can probably see that there is a danger in applying the proportionality test, that you're imposing a great burden on the Crown Court and requiring a lot of additional evidence, and that's what makes tempting a rough and ready approach. But your answer to Lord Kitchen, which is in effect that it's curious if the employer can't claim against the employee, yet the employee is said to have obtained a benefit, maybe a slightly risky approach to take, because the Crown's approach against you is quite straightforward. The whole salary is the product of illegality, and if the court isn't satisfied that the analogy of full reimbursement of the loser is a good analogy, then the Crown may be right and the whole sum is sought.
That's why Mr. Andrews didn't concede the appeal, my lord. Our respectful submission will be that it would be disproportionate for the reasons which we have canvassed in our written case and as to which I've already addressed the court.
But you say it's disproportionate to go for the whole sum, and the consequence is that nothing can be taken.
My Lords, if there is no evidential basis upon which an alternate figure can be identified, then that must be the consequence.
Unless Parliament intended, Parliament must be taken to know the realities in the Crown Court, unless Parliament intended a broad exercise to be taken by the court of what they thought was a fair balance, having regard to such evidential material as was before them.
My Lord, Parliament plainly recognised in our respectful submission that the statutory confiscation regime created by POCA was capable of operating in any particular case in a disproportionate way.
Well, Weyer gave them a clear direction in that.
Precisely so, my Lord, precisely so. But the fact that it was necessary for the Supreme Court to do that demonstrates that confiscation orders were being sought and obtained in a manner which was disproportionate. And Parliament plainly accepted that that was the case, because the remedy which was directed by the court, this court in Weyer, was adopted by Parliament in the amendment to section 6.5 that it brought about. It's our respectful submission that it must follow that now Parliament accepts that the mandatory unfolding of the mandatory regime can result in a particular case in a disproportionate order. And section 6.5 is the last chance saloon for the disproportionate order to be avoided. And it was as it was in our case. And that last chance saloon is particularly to be occupied by those who have made restoration or something analogous to restoration. And though it is true that, as I've indicated, employers may be disappointed to learn that to learn the deficiencies and the lies that have been told to them, that disappointment is not capable of calculation. None of the employers or particularisation in terms of pounds, shillings and pence. And it will not do, in our respectful submission, for a court, a Crown Court, to say, well, though I have no basis for saying so, I'm going to say that 10% of your salary reflects the expectation that your employer had that you would be honest and truthful. And that proposition, my lords, can be tested in this way, by reversing the position. Suppose Mr. Andrews had withdrawn his labour and said that with effect from the 1st of April, his lies not yet having been revealed, with effect from the 1st of April, I'm going to stop working. Well, it wouldn't have taken very long for the entirety of his salary to have been turned off. It wouldn't have taken very long for his employers to have stopped paying him in full. They would not have paid a residual 10% or 12% or such other figure as reflected the fact that when he applied for the job, he said he was honest. They wouldn't have continued to pay that percentage. Rather, they would have turned off his salary in its entirety. And that is because, in our respectful submission, what he was being paid for was not the efficacy of, or accuracy or truth of his initial application. He was being paid for the work that he was doing and doing to the satisfaction of his employers.
But if we were to reject that submission and we were to say that he was being paid as a person with those qualifications to carry out the work which he carried out, what then? What would your defence be to the Crown's case that they scooped the lot?
Our our defence would be that the effect of that argument would be that not only upon his conviction for the offences was Mr. Andrews to be sentenced to an immediate custodial of 2 years, which penalty, not only would he face that criminal charge, but he would also have been forced to disgorge the entirety of his salary up to the limit of his realisable assets, which salary he had earned by virtue of the work that he had been done.
But the hypothesis is that he hadn't earned the whole salary by the work which he'd done, because who was being recruited was a person who had the qualifications that were specified.
Well, my lord, even those who lie are entitled to convention rights and the protection of their convention rights and the imposition of a confiscation order which is proportionate. And if such an approach were adopted, in our respectful submission, not only would Draco look to his laurels, but there would be no distinction to be drawn from the circumstance of the shelf stacker or the pretending surgeon, or in any of the other cases that were described in the Court of Appeal as so unappealing because they permitted of no differentiation between those who had done the work that they had done lawfully and those who did not.
Can I take you to a slightly different area, and that is that you referred in your written case to some employment cases.
Yes.
And the aim of the legislation, POCA, is entirely different from the aim that you have the aim of POCA is to remove the proceeds of crime from a criminal. And so isn't that the major distinction there?
My lords, I accept that. I accept that. However, it is, in our respectful submission, relevant to the restoration argument. And the reason why, in those civil cases, former and disappointed employers have no claim against their lying former employees is because they have already had the benefit of the work that was done by those lying employees. And therefore, that is the point of overlap in our respectful submission between the civil regime and the criminal regime, because they assist us in the demonstration of the fact that Mr. Andrews has made full restoration. His employers could not have sued him for the return of his salary.
I wonder if that's quite correct. Imagine a case in which a prospective employee obtains a golden handshake of £1 million. Day after he's paid, they find that his application is fraudulent. They can get the money back.
My lords, I completely accept that. Yeah. I completely accept that. That is a product of the seemingly the apparently loose causal test. That there may well be circumstances in which such a handshake would be capable of amounting to benefit.
I'm not thinking under POCA. I'm thinking under employment law. There would be nothing stopping the employer in such circumstances suing his employee to say, I want £1 million back.
Yes, and there would be nothing in POCA where if the offence charge was fraud by misrepresentation to your former employer, to your intended employer, you may not even have commenced employment, and the fraud is obtained the £1 million by deception that you had that you had a gold DV when you didn't, then you would have obtained, as a result of or in connection with your lies about the Duke of Edinburgh award, the £1 million, and there would be no difficulty. There would be no difficulty with restoration in those circumstances either, because you haven't actually done any work pursuant to which you were given that golden handshake.
So you're really asking us, I think, to posit, let's imagine that Mr. Andrews was sued in the tort of deceit.
Yes.
What damages could the claimant recover, leaving aside any reputational damage? The damages they could recover would be zero, because whatever sum has been paid out by the employer is matched by the value of the work coming back. Therefore, the answer is nil damages.
Upon which we rely on Rubastic and all of those other cases which are cited in that section of our written case.
The fact that it was induced by fraudulent misrepresentation can't really pin any financial sum on that other than the consequences in relation to the work done.
My Lord, yes.
But there can still be coherence of the legal principles by virtue of the different aims of employment.
My Lord, yes.
And also the POCA.
My Lord, yes. I do not ask too much of the civil analogy. My Lord, can I take the court, please, to the judgment below, which is at EF 123. And my Lord Kitchen directed my learned friend to paragraph 98. And in particular, I think my friend was directed to the sentence commencing line 4. Further, whilst he had obtained the positions dishonestly, they were positions which he was otherwise lawfully entitled to hold. There was, for example, no legal bar and so forth. This overlaps with what we have been discussing concerning the pretend surgeon / surgeon pretending. In our circumstances, he is, in our judgment, to be taken as having given full value for his remuneration. He is therefore to be taken to have made full restoration. A confiscation order would accordingly be disproportionate to the aim of the 2002 Act. It would involve a double recovery. And perhaps the element which I had insufficiently addressed in my answers to the various observations made to me was the extent to which it would involve a double recovery.
Double penalty.
Double counting.
Well, it's not a double. I mean, we've got to be a bit careful with terminology here, haven't we? I mean, it's double disgorgement or double counting, but we're not concerned with a penalty in the first place. I mean, isn't the point that the Court of Appeal is making, it's the point at which it goes into being a penalty that we need to step back?
Well, the penalty intended there, my Lord is quite right, the confiscation regime is not intended to amount to a penalty. The reason it would have done, had a confiscation order been imposed against Mr. Andrews, or upheld against Mr. Andrews, was because he had already made a payment analogous to restoration by virtue of the work that he was doing.
So there was nothing to disgorge?
There was nothing to disgorge. And therefore it would have amounted to a fine to require him to pay monies pursuant to a confiscation order. And it's our respectful submission that paragraph 98 is unassailable pursuant under my friend's approach. My Lord Stevens asked my learned friend to identify the sort of occasions that the court may have had in mind in where, when at paragraph 34 it identified that there may be other cases and invited my friend to identify an example of the sort of other case that might arise. And the one that occurred to me, my Lord, was the case of Davy. And Mr. Davy had a neighbour. It's tab 32 in the bundle. Mr. Davy's neighbour had a tree, subject to a tree preservation order, which obscured his view of the harbour at Poole. And so in the dead of night, when Mr. Davy knew that the neighbour was going to be away out of the country, he procured the services of a myopic tree surgeon who was content to assist him in the middle of the night to chop down said tree. And the neighbour was obviously disappointed, as were the local trading standards and environment health officers, and they brought proceedings for the offence of chopping down a tree contrary to a tree preservation order, for which offence Mr. Davy was fined. And evidence was before the court as to the increase in value of Mr. Davy's property by virtue of it now having a view that it didn't previously have, which increase in property value was £75,000. And so Mr. Davy was subjected to a fine of, I think it was £50,000, and a confiscation order, being the amount that was obtained as a result of or in connection with, of £75,000, being the increase in value of the property. Now, had Mr. Davy gone on to sell the property, he would have obtained the value of his house plus £75,000. For the sake of argument, £575,000. By reason of the loose causal test, it would at least be arguable that that £575,000 was obtained as a result of or in connection with the offence of chopping down the tree. In particular, if the purchaser had expressed a desire to enjoy the view. In particular, if the purchaser and Mr. Davy had conspired to chop down the tree. Yet, in such circumstances, it might be, there's no question, of course, of Mr. Davy restoring the tree. It couldn't be true restoration in that case. A confiscation order in the sum of £75,000 was not appealed, would be proportionate. A confiscation order in the sum of £575,000, though permissible under the Act, as a result of the statutory overkill, would, in our respectful submission, be capable of being an infringement of the A1P1 rights that Mr. Davy enjoyed. But even that example, my Lord, is itself capable of being nuanced depending on the facts. If, for example, there was a conspiracy with the vendor, with the purchaser, as I suggested. My Lords, can I return to the question which I know is troubling the court, which is the possibility of the identification of some measure short of 100% of the salary? That might be an appropriate one. And it may be that it chimes with that which my learned friend has expressed in his written case and that which appears in our written case on the topic of partial restoration. Mr. Andrews cannot restore that part of his salary which is attributable to his lying on the CV. There are cases of partial restoration before this court. Weyer itself was a case of partial restoration, where originally the prosecution had contended that the loan and that which flowed from the loan should be part of the benefit figure. But the court held that the loan itself, which was fully secured against the property that had been purchased and was never in the possession, as it were, of the defendant, because it was automatically protected the interests of the lender, that loan was not to be included in the benefit figure. That loan was excluded because partial restoration had been made of the benefit that had been obtained when the property was sold and the loan was returned to the loan was obtained, returned to the lender. So the element, forgive me, the point that I'm stumbling towards is that the partial restoration was capable of precise calculation by the proper application of the legal and appreciation of the legal machinery that was at play through the obtainings which were predicated. My Lord, might I turn to Asplin? My learned friend referred to Asplin, which illustrates the fact-sensitive nature of the proceedings. Asplin commences at page EF 434. And Mr. Asplin was the managing director of a company called DAS Legal Expenses Insurance. And he was assisted by a co-defendant within that company called David Mark Kearns. And Sally Ann Jones, in cahoots with her co-defendants, set up a medical report company, which I think went by the unimaginative name of MedReport. In any event, by virtue of their respective positions, Asplin was able to direct to MedReport work which MedReport was able to monetize. And in that case, the prosecution, on a private prosecution, contended for the totality of the salary of the defendants to be included within their benefit figure. And could I direct the court to paragraph 41, please? And an important point, which I now respectfully submit, which I hope we have included aptly in our written case. At paragraph 41, the judge concluded that Asplin had, to some extent, done a good job as CEO, and added that if he had a general discretion, he would have exercised it by discounting about 1/3 of Asplin's salary from the calculation of benefit. However, he recognised correctly that he did not have any such discretion, and noted importantly that any discretionary amount would, in effect, be plucking a figure out of the air. Now, it's our respectful submission that His Honour Judge Beddoe, in the case of Asplin, should have succumbed to his instinct for fair treatment of Mr. Asplin. The exercise of discounting by 1/3 the salary would not have been, in our respectful submission, an exercise of discretion. It would have been a reflection of the evidence which His Honour Judge Beddoes had seen through the course of the proceedings. It was, in other words, a judgment based on evidence and not the exercise of a discretion. My Lords, it's to be contrasted with that which appears at paragraph 54 at EF page 445. In respect of the confiscation order intended to be imposed upon the co-defendant James, this may well mean, as Defence Counsel submitted, that Jones will be reduced to living on state benefits if she cannot obtain full employment. But that is the inevitable consequence of a confiscation regime which deprives a defendant of all her realisable assets if they are less than the benefit obtained from the crime. When Defence Counsel submitted to His Honour Judge Beddoes that Jones would be reduced to living on benefit and therefore the confiscation order ought not to be made, Defence Counsel was appealing to a discretion which His Honour Judge Beddoes did not have. By contrast, when His Honour Judge Beddoes assessed that a third of of Asplin's conduct he would have made a discount for, that, as I've indicated, would have been, as it was by Mr. Justice Cook in Hayes, the exercise of a judgment. Now, in Asplin, paragraph 46, the prosecution was able to identify all of those elements which justified the submission on the facts that it was appropriate that the totality of Mr. Asplin's salary should sound in a confiscation order. And items 1 to 8 demonstrate the extent to which Asplin's criminality was woven into his conduct within the company, and the extent to which it can properly be said that he had deceived and committed criminal offences whilst deceiving his employers. No such list is capable of being drawn for Mr. Andrews. There's only one point that's capable of being said against Andrews, namely that he lied at the point of commencement of his proceedings.
I was trying to think, and it may not be analogous, I was trying to think in terms of other areas in the law where one takes a broad brush approach. And one potential area, I haven't fully worked it out, is a Smith & Manchester Award for the impact of personal injuries on future employment prospects, which involves looking into the future and seeing how an injury is going to have an adverse effect on one's chances of earning an income in the future. And that's a very broad brush approach. And I just thought that it might be somewhat equivalent to taking a broad brush approach to saying, well, what is the proportionate result here of somebody who has manipulated their employment prospects? I was wondering whether that is truly analogous or not, or whether there's anything to be gained from it. Or...
My Lord, with the greatest of respect, we submit no.
Yep.
And the reason that we so submit is that this is an entirely different context, and context, as we know from Bank Mellat, is everything in the judgment, the assessment, the proportionality assessment. And this, my Lord, that the confiscation order results in an order in default of which a default sentence will be served up to 14 years now is the maximum default sentence. And that is a factor which it is, in our respectful submission, appropriate to take into account when determining where the proportionality assessment should lie. My Lord, can I... the court will appreciate I'm reviewing those parts of my notes which haven't yet been the subject of submissions. Can I direct the court to the Court of Appeal judgment at paragraph 56, which appears at EF page 115. And, my lords, at paragraph 56, Lord Justice Davis describes the approach to disproportionality laid down in Weyer as relatively rigorous, which caught our eye as a qualification which might invite analysis. And it was that conjoined with the subsequent reference at paragraph 84 to the Bank-Mellat approach, and indeed the observations of Lord Sumption about the exacting analysis that might be brought to bear in the proportionality test, that we identified as hooks, as it were, that might encourage this court to a consideration of whether the Bank-Mellat approach might result in a more rigorous approach than the relatively rigorous approach which has been identified by Lord Justice Davis. But having identified that, I don't think in the light of the submission, the observations during my learned friend's submissions, that I perhaps need to take the Bank-Mellat side of the argument any further unless the court invites me to do so. I would just mention this, that it arose from a note which I caused to be sent to the court, which I hope has reached the court. It doesn't have an EF number, but it deals with cases subsequent to Bank-Mellat, one of which it was in a specifically criminal context, namely Halcrow and others, in 2021 2 criminal appeal reports.
Yes, that's in your respondent's note.
Yes, that's correct, my lord, yes. I would not wish the court to be under the misapprehension that the Bank-Mellat approach had been confined only to civil cases. It has also been applied in the criminal context. That case concerned the convention rights of druids and lunatics, in the sense of those who were interested in the moon, being able to gather at Stonehenge, and whether the infringement of their rights to do so, created by created by a regulation that prohibited their access to Stonehenge, whether they represented a proportionate infringement of their Articles 8, 9 and 10 rights of religion and so forth. So just wanted to, in the light of my friend's observations about the Bank-Mellat being confined to the civil setting.
Well, I think we've had a few cases in the criminal context where proportionality has been important in Bank-Mellat.
Yes.
In addition to the ones you've mentioned.
Thank you, my lord.
But am I not right in thinking that we don't need to separately look at the jurisprudence behind Bank-Mellat, given that we're given a straightforward statutory requirement to look at proportionality under 6.5? I mean, it's not being suggested that there's any difference, is there, between how we would interpret that and what one would do under the fourth element of Bank-Mellat?
It may be, my lord, and I think I tentatively advanced this in the written case, that, and indeed it emerges from the case of Box, for example, that my friend cited, that there is a danger, I've used these terms, that the statute is marking its own homework if the proportionality test is focused only on the statutory purpose of legislation. And in our respectful submission, a review of the authorities demonstrates a focus upon stripping the criminals of the proceeds of crime, which naturally falls into question 2, whether the measure is rationally connected to the objective. And so the approach that is adopted emphasizes that purpose of the POCA regime. And because the wider test is not embarked upon, the factors which are more likely to be caught by those wider tests tend to be lost.
But how can you apply, in the context of Section 6.5, how can you apply the disproportionate, the requirement of proportionality beyond addressing the fourth of the Bank Mellat tests? I mean, how can one answer, with this statutory steer that we're given, surely 1, 2 and 3 are already dealt with, and all we're concerned with is the fair balance?
Well, my Lord, with respect, item 3, question 3, invites consideration of whether a less intrusive measure could be used without unacceptably compromising the achievement of the objective.
Well, how would that work out in this context?
Well, for example, in the case of sale, it may have been argued that, and indeed the Court of Appeal found, that to impose a confiscation order predicated on the totality of the turnover of the business, as a result of the bribed contract, that was disproportionate. And a less intrusive measure was found, namely the confiscation order being confined to the profit. And my Lord, I think the point that we would seek to convey is that the application of such a test permits of a more nuanced approach to the question of confiscation. When Lord Chief Justice Judge was dealing with the case of Nelson in 2008, the remedy to the over-strict, draconian application of the confiscation regime that was opened to Lord Chief Justice Judge, was the abuse of process regime, which is a blunt instrument permitting only of a binary outcome. This is an abuse, therefore stay. And Lord Justice Judge strictly confined the circumstances in which an abusive process might arise, and observed that where the act is being followed, it's difficult to see that an abusive process might arise. If I can just direct the court to that. It's at tab 17. And at page EF 659. And at the foot of page 659, in the passage entitled Abusive Process, can I direct the attention of the court to the Court of Appeal detecting that confiscation orders are perhaps being too readily abusive process, staying confiscation proceedings.
So where are you reading from?
I'm reading from the foot of page 659 and paragraph 34.
Yes, I see the very foot, yes.
Yes, and the reason I'm showing the court this dicta was to demonstrate the historical development which we say has occurred. The abusive process regime was the means of mitigating the draconian impact of the confiscation regime. But over the page to page, paragraph 35, The court observed as follows: however, to conclude that proceedings at the foot of paragraph 35, properly taken in accordance with statutory provisions, constitutes an abusive process is tantamount to asserting a power in the court to dispense with the statute. And therefore, the abusive process regime was not open. An abusive process not being open in circumstances where the intended interference with the convention rights was within the statutory provisions creating the confiscation regime.
Just to take you back to your point about the Sale case, I don't think we find there, do we, any at least explicit reference to what was being done as coming within the least intrusive measure type provision? No.
No. I accept that, my lord. I hope I said that what was done in Sale was capable of being brought within question 3 within the Bank Mel Act test. The court was not expressly doing that, but it did adopt a less intrusive measure. And
which could be the consequence of answering question 4.
Yes.
And indeed, to take up Lord Hodges' point, that there's a margin of appreciation allowed to the state in relation to the measures to be taken. The legislator here is the constitutional body that takes that, adopts the margin of appreciation by imposing statutory rules. And those statutory rules basically dispose of points 1, 2, and 3, leaving 4.
Well,
because, for instance, at page 700, paragraph 93, and I haven't looked at the actual authority itself, that's Jan against Germany. There must be a reasonable relationship of proportionality between the means employed and the aims sought to be realized by the measure. In determining whether this requirement is met, the court recognized that the state enjoys a wide margin of appreciation. That's not this court, it's the state. With regard to choosing the means of enforcement to ascertaining whether the consequences are justified in the general interest for the purposes of achieving the object of the law.
Yes. My lords, yes.
Right.
Yes. I think the submissions that I was advancing were intended to address those cases, such as Box, which was advanced to the court by my learned friend, which focus upon the statutory purpose and have resulted in the statutory purpose being the principal steer to the assessment of proportionality. And it was that led to the observation that it is the state, as it were, marking its own homework, and the circularity of the argument, because the statutory purpose is in danger of trumping the question for impact on the individual. Whereas Lord Reed's formulation allows for the proper identification of explicit value judgments which are required to be made in reaching the proportionality test.
the Court of Appeal, paragraph 79(2), where they say it's not a proportionality assessment, refer to a case of Morrison. Do you have that?
Sorry, my lord.
79(2), where the Court of Appeal say that it's not a public law type proportionality assessment, refer to a case called Morrison.
Yes, sorry, my lord.
It's page 119. Do we have that one?
We don't have that authority in the bundle, I'm afraid. It's referred to also at paragraph 66.
Oh, yes.
Page 117.
Right. So they may be referring to that paragraph.
Yes, that seems to be what they're referring to. Yes, it's the proportionality exception has although important, has a more limited scope.
Yes. Yes. My lord, I think that probably completes my submissions, unless there's any particular matter I can assist further with.
Mr. Ashley Norman, thank you very much.
Thank you very much.
My lord, I tried to confine my points to particular points that have arisen. I think the query was raised upon the issue about the burden and whose burden is it in relation to establishing an order must be proportionate. If I could invite your lordship to turn to the case of Harvey, and it's found at EF 502. It doesn't explicitly address the issue, but at paragraph 35, which is on page 502, if one was to go into the middle of paragraph 35, there is a passage which starts first, although the burden may be on the Crown to establish the gross value of the benefit obtained by the defendant, in this case some 2.275 million, the burden of establishing that a sum, and if so, what sum, should be deducted from that value to reflect VAT accounted for to HMRC lies on the defendant. It doesn't, of course, there deal with the issue of proportionality, but certainly one can see a scenario that once the issue has been properly raised, of proportionality by a defendant, there would be an obligation on the prosecution to rebut what was said. But I accept that there, it's not clear whether the words, and if so, what sum, are taken to include the issue of proportionality, or whether it's a separate issue. Certainly one could understand the position that having been raised, that the Crown would certainly be expected to deal with it. Can I just deal with a number of small other limited matters that have just been dealt with in relation to that case of Cook that was raised by my learned friend? What we took in relation to that, akin to what took place in relation to Sale.
Which case is this?
Forgive me, the case of Cook.
Cook.
Hayes.
Forgive me, Hayes. It's Mr. Hayes, forgive me. Where it's the case involving the bank employee. Forgive me.
Mr. Justice Cook's case.
Forgive me, Mr. Justice Cook. Forgive me, looking at my notes. Mr. Hayes, and where the court there, in essence, we say, sought to put him back in the position prior to his offending behaviour. Akin, we say, to what occurred in Sale. Having reflected on the invitation about whether there was such a halfway house in relation to this case, our initial reaction was that perhaps in line with my learned friend as to say that really the position between the two parties is a stark one, and it's all or nothing. And what I'm about to say, I hope in no way belies in any way consideration that we accept that there are weaknesses to the submissions that we have put forward. However, it was advanced as a submission by the Crown in the Court of Appeal. And can I invite your lordships to turn to EF page 220? No, it's the actual, forgive me, 220 please first. Where your lordship will see it, paragraph 66, there was an invitation at the original application for leave between the court and Mrs. Reynolds, who appears as junior counsel today, about this issue, because obviously this is something that the court there were contemplating. And when it was framed in terms of as to whether it might have been possible to value the pecuniary advantage obtained by reference to the opportunity to earn more as a CEO of St Margaret's Hospice than he was earning at the time he was offered the position. And one can see what's said at paragraph 67. It's asserted at paragraph 40 of the revised skeleton argument that Mr Andrews in fact took a pay cut. That was looked at in between the time between the preliminary application for leave and the full court, and a statement taken and included within the bundle. And your lordships can see what is set out at paragraph 68, that in fact, that between 2003 and 2004, in other words, it is prior employment, he earned gross pay of $54,361. And his salary at St Margaret's Hospice was between 2005 and 2006 was $75,000 per annum, equating to an increase of $20,639 or 38%. But calculated it over a 10-year period, that amounted to an increase of $206,390 in relation to count one alone. And while the Crown, for the same reasons that I've already indicated here today, whilst the Crown there did not endorse such an approach, it did follow that Mr Andrews did improve his financial position as a result of his appointment as CEO of SMH. This was dealt with in the court below at EF page 123 in fairly short order at paragraph 99, where the court said this: there was some brief discussion before us as to whether at least the appellant should be required to be subject to a confiscation order reflecting a sum equivalent to the difference between his prior earnings and the increased earnings he received at the hospice. But such an approach does not fit with the approach we have outlined above, which I think was dealt with my learned friend at paragraph 98. And indeed, as Mr Evans fairly accepted, and I think it's fair to say upon some fairly robust questioning at that point, that it could be said to be arbitrary in its outcome, and gave the example, should the outcome on benefit be different simply because he may have been employed before he gained the post. Having reflected on that, one could see certainly situations, for example, where a first officer or co-pilot wishes to have the increased salary of a full airline pilot, and that would be a measurable increase in his earnings and would be quantifiable in his benefit. And of course, one can see for a number of professions where that could cut across the board. So I'm not sure if my learned friend was making the submission that there is no evidence upon which to base, in fact, there was an increase. In fact, there was and is evidence in relation to Mr. Andrews, which this court may feel reflects a halfway point. The court also indicated whether it might be appropriate to adopt a percentage approach. And, for example, along the lines of contributory negligence, many a personal injury practitioner is conscious that if they have a driver who is driving without a seatbelt and is involved in a road traffic collision, there is a fixed percentage which is deducted in all cases. Clearly, one would hope that in relation to many examples, such as the airline pilot, one could clearly see what the identifiable increase, as occurred, for example, in the case of Hayes, would be. But in those cases where there was not, and where a individual such as Mr. Andrews had been working for a period of many years under an operative deception, one could see a situation where, if given clear guidance by, indeed, this court as to a percentage that could be applied, that might be a way forward in terms of a halfway house. I certainly would submit that the former, in other words, being able to identify the airline pilot and the increase in aims, is clearly a much easier way, and how the situation is adopted where an individual who we would say has never given full value, because there's always been, is operating under a lie and it's not what the employer wants. But one can see that does apply and has been used in other areas. The only final point, as I would draw your Lordship's attention to, was this, that my learned friend at EF 659 drew your attention to the prevalence of abusive process applications being made, and indeed being made all too readily. I think it's fair to say, and I don't think anyone would disagree, is this, that following particular the case of Wire, and indeed in particular the case of Andrews, that is not a position that is now being encountered by the courts. But I can say that no more on an anecdotal basis than be able to put anything concrete in front of the courts. Would your Lordship just give me one moment? Can I assist any further at this stage?
Well, I said at the outset that I wish to give you the opportunity to come back in writing,
yes,
in respect of the possibility of a halfway house. And I don't know how Mr. Evans is. I hope he's not seriously ill. But is that an option that you'd like to take up, to be able to discuss with him and produce a short written submission on that matter? I mean, what I have in mind, of course, is that the imposition on the Crown Court of a requirement to carry out a proportionality exercise in the context of confiscation proceedings would not, I think, serve a good purpose if it were to create a very lengthy extra evidential hearing looking into detailed matters, and one wonders whether or not that what Parliament may have been contemplating was a fairly rough and ready exercise in order to avoid gross disproportion. But again, I would welcome your and Mr. Evans' guidance on that matter, and of course, Mr. Ashley Norman would have an opportunity to respond to such written submissions.
Yes. Can I say I'm unwell as to the full extent of how unwell Mr. Evans is. I don't think he's particularly well. What I was going to ask for, we would welcome that opportunity to reduce that to writing. Could I have a little longer time than would normally be asked, but be ordered, to give him a little bit more time to recover? I had something in the region of 21 days, but I don't know if that's it's imprudent for me to suggest. I know normally one would expect, of course, a response much more quickly.
No, realistically, I think we will have to give a reasonable amount of time. If you were able to do it more speedily,
of course,
then that would be clearly very welcome while matters are fresh in the minds of the court.
Yes.
But we can set an initial deadline of 21 days. And if there are difficulties because of Mr. Evans's continued indisposition to comment on whatever work you're carrying out,
yes,
then you can clearly send a message to the court to explain the circumstances.
May I see, just to inquire, just in terms of the rough and ready exercise, with what your lordship occurred as what I was talking about, and this was the second option, in other words, of effectively the
I don't know. That is one of the options that might be available. I'd be interested to have the submissions from parties on whatever option they think is suitable, and the pluses and minuses of the various options. Because I am aware that there has been academic criticism of this court's decision in Ziegler, where it was adopting a common position that a proportionality test should be applied. That was the common position of the parties, but that there has been academic criticism that that was imposing a heavy burden on the Crown Court, who are not used to carrying out such exercises. So, bearing the practicalities in mind, the second option is an option, but it's by no means the only one. You've clearly given us the alternative option of looking at evidence of improvement and such like.
Yes, thank you very much.
Well, and would you be able to respond maybe within 7 days after receiving the paper from the Crown?
I'm sure so, my Lord, yes.
We'll proceed on that basis. The court is very grateful to counsel for their submissions, and particularly counsel for the Crown for having to step in at extremely short notice to present the case which otherwise his senior would have presented. We're very grateful to you for that. We're also grateful to all those who have assisted counsel in the preparation of the case that we've heard today. It raises a very interesting question. We will await your submissions, and we will then try to produce a judgment when we can. Thank you very much. The court will now adjourn.